Hi, I'm Elmer Young, a Georgia DUI lawyer, and welcome back to DUI A to Z. So as we get started, I think we should do first things first. So let's talk about the administrative license suspension procedure. This procedure is one of the first legal steps that most people will have to go through after they've been arrested for DUI. This procedure is a summary procedure, which means it happens pretty fast. It's a civil procedure, so you're not guaranteed the same rights and defenses that you might be afforded in a criminal case. It makes it easier for the state to prove their case. It makes it a little bit more difficult for you to preserve your driving privileges. That's why it's very important to pay attention and to make sure your lawyer pays attention to each step of this phase. To begin with, when you're arrested, the officer is going to read from a little card what's known as the implied consent warning. That implied consent warning is designated language by the state of Georgia, and it ends with a question. That question will always be, will you submit to the state-administered chemical test of your blood, your breath, or urine? Okay, it'll always be one of those, and it's the officer's choice. There are some other opportunities to obtain your chemical fluids by way of a warrant that the officer could go through, but you have the absolute right to refuse that testing. There are consequences one way or the other, as you can well imagine. But then he will issue you or is supposed to issue you a document called a DDS 1205. That DDS 1205 is a document that gives you a 30-day driving permit, and it also gives you notice of that officer's intention to suspend your license administratively. So be sure and read both sides of that document, and you'll see that you only have 10 business days in which to file a written request for a hearing. Failing to do that, your license will be automatically suspended for up to 12 months. So we want to make sure that you take the steps that are necessary to assure we can extend your driving privileges out beyond that 30 days and perhaps for a few to several months. After the DDS 1205 is issued, you're typically then, it's given to you about the same time you're released from the jail. And then you're going to be essentially filling out that form to apply for a hearing, and that form is available at the DDS website. I would not recommend you use it because they ask you to provide them information that they're really not entitled to have. We will typically send you our form. It doesn't have our name on it. There's no strings attached to it, but it's a form that doesn't contain that language or those questions that the state wants to get from you, and has been used for many, many years. And there's no charge for that. You just have to pay the administrative appeal filing fee that goes along with that. And then we just sort of wait for the date and time of the hearing that will come to you. And if I'm hired in the case, typically you will have already filed it. My name won't be on it. So you need to make sure to let me know, or whoever you hire know, when your hearing is scheduled so you can make sure and make arrangements to be there. Now this hearing, as I told you, and it's referred to as with the abbreviations ALS hearing, which stands for the Administrative License Suspension Hearing. But this ALS hearing will be at a time and place that's designated. They're going to bring a judge over from Atlanta. Typically, they may or may not bring over a special prosecutor to support the state troopers who may be involved in some of the cases. And it doesn't happen in every jurisdiction, but that's something that you need to know and be prepared for. Because it's a civil case, these hearings can be very problematic for certain drivers. The burden of proof that is on the officer to prove that case is fairly minimal. And so you have to take that hearing and its consequences and factor it in your long range prospects or plan or strategy for the entire DUI case. Failing to do that, you can lose on one side and win on the other side, or vice versa. But you want to try not to lose any more than what you have to. You've already lost enough with being arrested, losing your time going to jail, posting bond, hiring an attorney. It goes on and on and on. At that ALS hearing, there'll be a lot of other drivers who are there along with their attorneys, and there's going to be a lot of discussion among them. They're going to be settling cases and working cases out to the best of their ability. For those that actually have a hearing, it will be fairly informal. The officer will go over basically the paperwork he's prepared and testify to that. Then the defense attorney would have the opportunity to cross-examine them, and depending on whether or not there was a test or whether there was a refusal in the case, that cross-examination could be longer or shorter. So once the case has been heard, then we'll all walk out together, and the judge will issue a written order in a few days, and we'll send you a document that will show you how to get access to your order on your ALS hearing. So I hope this helps you understand this initial part of most DUI cases, and we'll look forward to going on through the alphabet in future videos. Have a great day.